Mike.
The Criminal Justice Committee will come to order. Would the clerk please take attendance?
Chair Hope.
Here.
Representatives Andrews.
Here.
Carter.
Here.
Breen. Young. Here. Arbit. Devendorf. Here. Cerniglu. Here. Filler.
Yes.
Mueller.
Here.
Passat. Harris.
Here.
Legault.
Here.
Madam Chair, you have 10 members present. We do have a quorum.
Thank you. Representative Andrews moves to adopt the minutes from the March 12th meeting. Without objection, the minutes are adopted. Just an announcement, and it looks by the number of cards that everyone already knows this, but if you wish to testify, you need to fill out one of these white cards and make sure that it gets to the clerk. So we're going to start with testimony on House Bills 4556, 4557, 4558, 4559, and 4560. Our bill sponsors here. Oh, there you are. Right in the middle. Come on up, Rep. Wilson and Rep. Ayash, when you're settled there. I do want to say a couple of things before these gentlemen get started. This is not the end of a discussion, it's the beginning. So keep that in mind. I know this is an emotionally charged issue, and I completely understand that. And I also have to break the bad news that not everyone who wants to speak will be able to today. If you have something you would like on the record, you may submit written comments. It's just mathematically impossible to get the people who I have on my list testifying before 10:30, so I appreciate your patience. Now, Representative Wilson, Representative Ayash, go ahead.
Thank you, Madam Chair, for allowing us to take up this testimony today, and good morning, committee members. I'm going to dig right into the crux of this bill because we have a lot of folks that are wanting to have something to say today. And so this is the Second Look Resentencing Act legislation. What this says is that if you've been incarcerated for 10 years or longer, you can ask for a second look. The piece I want to make sure I highlight is that you are asking your same sentencing judge for a second look at your case. And your sentencing judge does not have to just take into account sentencing guidelines. It can take a holistic approach to everything surrounding your case, as well as what have you been doing since you've been incarcerated. And so they can take into account, have you been staying out of trouble? Have you been taking classes? Do you have degrees or trainings or certifications? Do you have a support system? Do you have a support system if you were to potentially be released later down the line? One thing I want to make mention right there is that this legislation does not release anyone. This legislation just allows for someone to ask for a second look at their case to be resentenced. A judge can also look at, is your conviction something that once was looked at one way, and now here we are 20, 30 years later looking at this differently. Think of cannabis, and they can take that into account, that this is clearly something that has changed over time. They can also take into account health concerns and health issues, your age. Are you in your late 50s, early 60s, and you're going through all kinds of health concerns? Clearly someone that if you were to be resentenced to something less and a parole board were to release you, you're clearly someone that is not going to be a threat to society. We know that the average age, the average lifespan of someone incarcerated is in their mid-50s, and so when you're looking at who would have first dibs on this second look, if it were to pass, would be those actually in that category of older age, someone with a lot of medical conditions. They would actually get to ask for a second look before anyone else. One thing I want to make mention, go back to what I just said, is that this legislation does not release anyone from being incarcerated. They would still have to go through a parole board process. So if your judge does resentence you to something less, you still have to serve your full minimum sentence, just as Truth in Sentencing says you have to. And then, once you're eligible for parole, you have to go through the parole board process. And then the parole board would end up going through a lot of the same things, but they use their own lens because this is what they do all the time, is look at folks who are incarcerated on any potential release. And so you can see right there that there are layers to this legislation. This is by no means a get-out-of-jail-free card. This is you saying, can you take a second look at my case? One thing I want to make mention is that there are some categories that I want to highlight. There are some individuals that won't be able to ask for a second look, mass shooters. You won't even be able to ask for a second look. And then you have some categoricals of folks who you can ask for a second look, but a judge can say, I'm not taking a second look. Some of those categoricals would be your CSCs, domestic violence, child explicit materials, different types of human trafficking. These types of cases, a judge can just say, I'm not taking a second look, and move right on to other cases. Those are the main highlights of the bill that I want to make mention. And I think at this point, I'll turn it over to another one of our bill sponsors, Representative Ayash.
Thank you, Representative Wilson. Good morning, Chair Hope, Vice Chairs Filler and Andrews, members of the committee. I appreciate the opportunity to have a discussion on what we believe is paramount to what makes America America. This idea that we have a criminal justice system that is checked and balanced by a legislative process that allows our country and our state in particular to assess what are we doing to keep our community safe, what are we doing to ensure that our society and our state and our communities here in Michigan are thinking about all the ways possible to create a world where we are helping people become better, we are holding folks accountable for their actions, and that we still believe in what I think is a uniquely American concept of redemption under the eyes of the law. So as Representative Wilson mentioned, the second look legislation would open up the conversation to allow us to have a process in place to assess how we are looking at our carceral system here in the United States of America. With nearly 50,000 people nationwide who are serving life sentences, I think it is important for us to think about what that means for those of us that are paying for that burden in the state of Michigan. As we know, someone that serves a life sentence will likely die in the prison that they are serving that time. And as people age, their complications get significantly worse when they are in the prison system. In fact, there's one statistic that suggests that folks are 10 years older biologically than what their age would suggest. So if you think about what we are paying as residents of this state, we're looking at upwards of nearly $70,000 annually in locking people up who are in very late stages of their lives. So this would allow us to think about a process to say, are there ways that we can assess someone's convictions? Are there ways we can assess what is the greater good and what is for the public welfare and the well-being of our society? Can we find ways to bring people to justice while also being good stewards of state resources that we are all entrusted to make sure that we overlook? So this legislation would allow us, as Representative Wilson said, to set up a process for those that are serving life sentences who have served at least a decade of their time to be able to come back to the judges and say, is there an opportunity for us to say that there is some form of redemption in the process? Because inherently, if we truly believe in our criminal justice system that there is a process for redemption and people are being punished and serving for the mistakes and the crimes that they made, then we have to trust that our system does something to rehabilitate those people in that process. Otherwise, how are we going to look at our criminal justice system and say that someone being locked up for 50, 60 years, if nothing about that process forced them to change, forced them to re-examine what they have done and holding them accountable for the pain that they have caused, then we are not doing right by the criminal justice system here in the United States of America. So, Representative Hope, I know we have a multitude of experts here today, and we're going to lean on their testimony. And I know we have folks with lived experiences, but I just want to emphasize one point in this process. It is easy to focus on those that have committed the crimes explicitly, but on the other side of that are those that the harm was done to. Victims have a significant role in this process. This does not happen without any engagement with the victims. This does not happen without the victim having the opportunity to directly engage in the process and determine, is there a point of redemption for this individual, or is the grief and the pain and the destruction that they may have caused too much to bear for them to be able to have that second look in the process? So with that, Chair Hope, I yield back to you.
Thank you. As a bill sponsor, I'm going to exercise a privilege here and just mention a couple of things that I didn't hear you gentlemen mention. One is that just to underscore how unsustainable what we're doing now is as a practical matter, as a fiscal matter. I recently had a corrections officer come to one of my coffee hours, and he told me that with the mandated overtime they're required to work, it's taking a toll on family life, mental health. People are quitting. People are committing suicide. Officers are committing suicide. There are currently 1,500 unfilled positions in the Michigan Department of Corrections. That is not safe. It's not safe for the public. It's not safe for anyone inside, and it's not safe for the officers. And these expenses and personnel shortages will just grow, as the gentleman said there. And the other thing I want to underscore is this is a gross racial injustice. 51% of Michigan's prison population is black. 51%. That compares to about 14% of the general population. And black prisoners are subject to longer minimum sentences. This is mass incarceration of black Michiganders. And this policy gives us a chance to demonstrate good governance, compassionate policy, as well as fiscally responsible policy. And I'll stop talking now and get to our experts and people with lived experience. I'm going to call up Ronald Simpson Bay. From the Just Leadership USA organization, and please go ahead when you're ready, and if you can, please keep your remarks succinct.
Oh, thank you, Madam Chair, and thank you, panel, for allowing us this conversation and for your service to the community. My name is Ronald Simpson Bay. I'm currently the Executive Vice President of Strategic Partnerships for an organization out of New York City called Just Leadership USA. We are a national criminal justice reform organization, and we advocate for these type of policy legislation. I'm a Michigan resident, former Michigan resident, born and raised in Michigan. I currently live in Atlanta, Georgia, and I came back here for this conversation. I have two personal reasons for this conversation. First, I served 27 years in the Michigan Department of Corrections on a conviction from 1985 to 2012 that was overturned by the federal courts in 2012, and I was subsequently released. But during that time, back in 2001, I filed a motion for release from judgment. Well, in 97, I filed a motion for release from judgment, and it was ruled on in 2001. The trial judge wanted to give me release, but he said he didn't have jurisdiction to do so. And he wrote a 30-page opinion outlining what he thought the relief should be. And that was on which I built my habeas corpus petition. And if I'd have had this opportunity in 2001, it's a good likelihood I would have been released at that time because the judge wanted to do so. And so that's one of my reasons for being here. My second reason is that my son, while I was incarcerated on Father's Day 2001, I was waiting for my son and my three daughters to come visit me at Lapeer Thumb facility, and they never showed up. And what happened, my son had been shot and killed by a 14-year-old juvenile on Father's Day 2001 while I'm waiting for them to come visit. And so the child that shot and killed my son, I advocated for him to be treated as a juvenile and not as an adult, because we know in Michigan they treat juveniles, they give them life without parole for murder. But I saw no useful purpose in this child serving a life sentence for his worst choice in his short life. So I advocated for him to have a second chance, for him to actually be able to come back and be a productive member of society. And that is part of my motivation for being here. I once read William Shakespeare said that past is prologue, meaning that history, it sets the context for the present. By knowing what has happened in the past, we can determine appropriate courses of action for the future. As we look over the lessons learned from the past 50 years of this mass incarceration movement, second chance legislation is currently certainly an appropriate course of action for the future. And I hope that you would consider doing so, that you give society a second chance, allow these people an opportunity to come back and be productive members of society instead of sitting past their livelihoods past the point of diminished returns. I thank you for allowing me to have this conversation.
Thank you, sir, and I'm sorry for your loss. Next, we have Nabil Avida. I'm sorry if I said your name incorrectly. Good morning. Please go ahead when you're ready.
Good morning. It's Nabil Zabib. Okay. First, I want to thank you all for having me and for your service. Thank you so much. I want to first describe to you who I am. I am Nabil Zabib, the son of Hani Zabib. 2 months before my wedding, my fiance came to me and said, your father's been shot. And a few minutes later, I found out that he was actually killed. As we were planning my wedding, we were getting closer. We had to now plan my father's funeral. One of the people that were convicted for my father's death was Penal Duke. Before I start, I know I don't have enough time, but I'd like to just show you a photo. This is Tuxie. She's a Pampu. She's my dog, and I don't got time to talk about her today. But if you want, I can. I'll describe to you why. It'd be part of this discussion. However, I just want to tell you that I don't want to be here. I did not want to be here. Demal didn't want to be where he is right now. But however, fate put us all here together today. I would rather be with my father, my children, celebrating, having fun. I am not the same person that I was when my fiance at that time came to me and told me what happened. I was very angry, and thanks to you all and to your work and your hard work and your legislation, you brought justice to our family, and therefore we moved on. I became a father, a very proud father, of a 2-time state champion, of a Ross graduate, wonderful, wonderful, amazing duplicate of my father, son, and therefore I am very proud of where I am right now. I think my father's death served everyone, as he did in his life. And surprisingly, it served Demal. Because of you, you passed legislation where you put Demal in a place where he has the ability to learn and become a better person. For 20 years, I did not know anything about Demal, but somehow I Googled my father's name. For some reason, it turns out about a month or two before Demal had put out a video. That video reached out to me, a father, a son, a father of children who don't have a grandfather. And I realized at that point that the man has served his time. And I realized that now we will be doing not the mal an injustice, we'll be doing the world an injustice, my children injustice, my father an injustice, if we were to keep the mal in jail. We need people like him to go out and speak and show the world what he has learned. We need him. I'm not here for the mal. I'm not here for me. I did not want to be here. I'm here for all of us. We here are all to serve on the small time that we are on earth. Whether we want to be in this room or whether we don't want to be in this room. And the mal needs to get out, needs to be released, and he needs to serve. Thank you.
Thank you, sir, and I'm sorry for your loss. We do have a member question. Well, we actually have several member questions, but we're not going to be able to get to them all right now. Representative Filler.
This is for the sponsors. The way I read this bill, the way I read the bill and the way House Fiscal says, no offense would disqualify an incarcerated individual from relief under the bill. So essentially, every murderer, every rapist, domestic violence offender, child abuser, arsonist in the state of Michigan who has served more than 10 years in prison for the most serious crimes we can commit now gets to petition for rehearing and resentencing. Am I reading that correctly?
Representative, so I have faith that our judges in our system are going to be fair and just in their assessment of what is and is not deemed as something that is redeemable. And I'll
just
say
want
this.
a yes or no on that one.
So this is
Representatives.
a part of the committee process, right?
Representative Filler, he's attempting to answer your question.
So this is a part of the committee process, Representative Filler. I welcome input from folks in this room, and as Representative Wilson mentioned at the start of this discussion, this is not the finality of the legislation. Part of this committee process allows us to deliberate and engage on what we think is and is not appropriate for us to work through. So if you have any amendments, if you have any recommendations, Representative Filler, I encourage you to share them with me in my office as well as the rest of the sponsors. That there are certain crimes that are irredeemable and that there are certain individuals that do not have the ability to get
But
released
that's not what the
based
bill
on that.
says. Representative, this says
The bill says that
they all get a review.
the bill says that they have an opportunity to petition for the judge to then go ahead and assess, is this something worth taking a second look at? It is not a carte blanche approach that anyone who petitions automatically gets it. Even right now, I mean, you have folks constantly writing letters, trying to get pardons, things of that nature. We're not preventing any of those individuals from engaging in that process, right? That is what our criminal justice system allows, is establishing processes for us to be able to allow people to say, are we going to be a system of justice or not? Are we going to give people an opportunity to work through that system of justice, whether we deem what they are doing acceptable or not?
Thank you. Thank you.
And I would add that the mass shooting perpetrators are off the table, off the bat. And then judges have discretion for a number of offenses, including the ones that you just listed, to deny a petition. They have discretion throughout the whole process, but they can deny off the bat.
Or not deny.
Okay.
Thank you.
Yeah, judges have discretion.
Thank you.
We have to trust our judicial system to a degree. I mean, it's not perfect, but that's what we have. And next, thank you, Mr. Abida. Next, we have LaWanda Hollister and Marilyn Stevens. You keep your remarks succinct if you can.
Hello. I am LaWanda Hollister, and formerly incarcerated. I went in as a juvenile offender. I served 36 years, and I have returned to society. And I stand here today in support of this bill, but I'm going to allow Miss Mary to start as I gather my thoughts.
Thanks. Thank you, Luanda, and thank you, all of you. When you hear from Luanda and when you hear from many of the of folks today, you are going to hear some extraordinary people. And what I want to say briefly, excuse me, I need to back up just a little bit. My name is Mary Lynn Stevens, and I'm here because I have relevant and maybe a little unusual set of insights that I hope will be useful to you, and also just to shine a light on the women in the system. They are only 6%, but they are a huge and important population, as you all know. So for about a dozen years, between 2007 and 2019, just before COVID, I was a prison volunteer, first at Scott Correctional when that was still open, and then at Women's Huron Valley. In Ypsilanti. So working alongside other volunteers, and lots of people there, of course, I spent roughly 10 hours a month working almost exclusively with the women who are in this purview, women who had been convicted of serious crimes and were serving sentences of at least 15 years. Many had done 10, 20, 30 already, and so these are the folks who, many of whom are going to be coming forward to you, to the judges for consideration. If this bill passes. And what I want to assure you of is when you hear these spectacular people who have done amazing work to bring the best of who they are back into the world, it's so easy to think, oh, they are the exceptions. There's not many people like that. There couldn't be many people like that. And as Luanda is a friend and we are part of each other's support system and all of that, I knew her very well when she was on the inside, and I know she's one in a million. I'll also say that in terms of readiness for a second chance, vis-a-vis the women and the life and long-termers that she served with at Women's Huron Valley, she's not the exception, she's the rule. She's the rule. It is, as other people have said, and probably will say more today, remarkable work to reckon with how you became the person you were, how you came to impact such harm in such profound ways, and how you can change that trajectory, especially in a rough place like a prison. But lots of people do it. There are multiple paths. Each one's unique. And I would say that the very best foundation starts with things that you can't take for granted in prison, like physical and mental health and access to your loved ones. And yet the human spirit can prevail. And so briefly, just to kind of furnish your imaginations as to how that transformation can actually happen at some scale inside, I'm just going to give you a couple of examples. I think it starts with the need. It starts with the hunger. That's what people have told me and shown me. And if that happens to align with a resource that's available, it can be the beginning of realizing that change is possible, that self-worth is real, and that sets the table. Often it's spiritual. Women can take advantage just beyond regular services and that kind of thing. I don't mean to minimize them, but for example, there are retreats and small scripture groups and prayer groups and individual spiritual journeys with clergy or other faith-based volunteers, some who have been with the same person for 5, 10, 15, 20 years. The impact is sustained and it's significant. Many women also need to heal from abuse.
Ma'am, I'm sorry to I'm very sorry to interrupt you, but I do
go
want to hear
faster.
from Ms. Hollister as
Okay.
well.
Let me say a very quick thing then. That so there are lots. There are religious. There are domestic violence healing. There are lifer groups that work on policy, and that they also work on themselves. So, and of course, there's education, which we know is life-changing for all of us, and is just as life-changing in prison. So. I will close now and give it to LaWanda with a 30-second story from Huron Valley. I have to tell you this. Joe Haveman's back there. About 10 years ago, about 10 years ago, he and another legislator came to Huron Valley to hear about, to work with them and talk about policy reforms. They did their wonderful presentations. They gave their very best self to it. Great in-depth Q&A, very professional. And afterwards, we're barely out of the building, and Joe was bursting, and he said, "Mary Lynn, are they all like that?" And so what I say to you is what I said to him at the time, which as many, many of them are, and with programming and with support, many of them, many more can be. So on behalf of all of them and all of us who will benefit from having them with us, I urge you to support Second Look, and thank you.
Okay, Mary Lynn, so they won't drag us out of here. I've seen it on TV. So I am LaWanda. I went to prison when I was 17, and I was considered a killer kid. I was a hellion when I first arrived. I was sentenced to 40 to 60 years, and I was going to do it my way because I could not see the 40, less known the 60. And there's a point in which something else has to be done. So I believe that this gentleman said we have to, I don't know, I'm getting all discombobulated. Let's back it up. I was a hellion. I am so sorry. I was a hellion. I was doing what I wanted to do in the prison. And at a point, it changed. You have to become a different person and do things differently to move forward. And we have to rely on our system of learning. That is what he said. See, it came back to me. We have to rely on our system of learning to be able to do that. So people aren't just sitting in prison for 20, 30, 40 years and just being there. And that's what happened with me. Once I was released, May 8th of 2020, I rooted here in Michigan because I'm not even from Michigan. And I've rooted here in Michigan, and I do everything that I possibly can to show that I have been redeemed. Thank you.
Thank you.
Do we have any questions?
Thank you.
No, thank you.
Next, I'm going to call up Alexandra Bailey from the Sentencing Project.
Good morning.
Good morning. Please go ahead when you're ready.
Thank you, Chair Hope, and to all the members of the committee. I do have a professional capacity, but I'm going to speak to you today not from my professional capacity, but as a two-time survivor of violent crime. I have only been safe from domestic violence for 4 years this coming November. I was brutally attacked with a metal towel rack that left me with a seizure disorder and a whole host of other issues that have been very difficult to deal with. And I also, I'm sorry, this is hard to talk about. When I was 9 years old, I was part of a sexual assault, double homicide scenario that resulted in the person who perpetrated against me serving life without the possibility of parole. And, I'm a full-grown woman now, but, imagine me at 9. And imagine a 9-year-old girl trying to treat vaginal tears. And ever since then, I have been very outspoken about survivors and what they need, and how we should be supporting them. I have the privilege of being on the impacted board of the National Victims Advocacy Network. I was also interviewed for the Crime and Justice Alliance's study nationwide on survivors about what it is that we actually want this system to be doing. I spoke to my perpetrator this past Christmas. I wished him a Merry Christmas. I was able to go through a justice facilitation process and learn that he himself had been brutally raped through most of his childhood. And it's also worth pointing out that this was an incestuous rape, so that element is also here. I take what survivors go through so intensely seriously. But I'm here to say that a lot of the people that I have had the privilege of meeting inside are also survivors. Some of my very dearest friends in the Michigan Department of Corrections are women who've been beaten, abused, stabbed in their pregnant stomachs. The system needs to go and check itself, because we don't look at survivors the same way 20, 30 years ago that we do now. There's a lot of cleaning up that has to be done, and for Black female victimhood, it was a long time before it was even taken seriously. This legislation is not antithetical to what survivors are here for. As a matter of fact, this legislation saw to it that it reached out to domestic violence groups and excluded people who were the most harmful. It doesn't mess with victim restitution, which is something that I'm also a huge proponent of, because victims need to be made whole again. This legislation is good. And if you were to actually read the studies about what survivors actually want, studies that I've been a part of, over 63% of us are for restorative and not just punitive processes. You want to know how you can help me, people like me, people who have to carry around this burden for their whole life, a burden that jail cells can't take away? You can create a system that is just and holistic, that rehabilitates people. Because if Brian, my perpetrator, was out here right now, he would be somebody that other young men who are being sexually assaulted could talk to, so that they wouldn't turn to anger and violence. And maybe another little 9-year-old girl won't end up like me. Thank you.
Thank you for sharing your story. We do have a couple of representative questions. Representative Young?
Thank you, Madam Chair. Thank you for your testimony. I'm just so grateful that you're here on today to speak to the fact that this is an anti-survivor legislation. That's not what this is. We're not against people. We're for all people. And you being able to have a conversation, you being able to say Merry Christmas to your perpetrator is no small thing. One of my closest friends was abused by her mother's boyfriend. And we fast forward 30 years, and she began to call him dad. He became her father after the abuse. And so we know that restoration can happen. We know that people can absolutely change if given opportunity. I think about the name of the correctional. We call these correctional. Correction means make right, right? If there's a mistake, we want to correct it. And so somebody just said here, a person's worst choice in a short period of life, a person's worst choice should not dictate the rest of their life when at all possible. And so I'm grateful, so grateful for your voice on today.
I remember my father, when I wished him a Merry Christmas, as you can imagine,
See?
my father wants to kill him, as most fathers would respond. And I wished him Merry Christmas on video in front of my father. And then my father said, hand me the phone. And I handed him the phone, and he said, Merry Christmas. And then he looked over at me and he said, I learned from you, baby. He said,
Healing.
I learned to be better because of you, baby.
Healing, healing. Amen. Thank you so much.
Representative Carter? Representative Mueller?
Thank you, Madam Chair. This is for the sponsors. Where did we come up with the 10-year mark? Because, you know, you have people that have been serving 25 years, which is, you know, 25 to life on a, but natural life is natural life, right? But where do we come up with 25? Because we're taking it down to 10 years to let a judge use their discretion to let somebody out. So we're basically cutting what life in prison is in half. That's not really giving discretion to the judges. I mean, we're taking a lot of discretion away. So I think that's a little bit overreaching. I think we need to be more concerned about the nonviolent offenders who are still sitting in prison after 10 years for drug crimes and things like that versus violent offenders. So
Please don't.
What's that?
Please don't.
I don't know who's saying that. Okay. Well, anyway, I just think I think if we're going to try to do something, it has to be a little bit more in the middle. And you know, 10 years is taking a lot of discretion away for somebody that's been, you know, in her case, she was a victim of violent crime and has learned to forgive. There's other people that it's going to take them longer than 10 years to get over the fact that somebody had raped them, murdered them, or not murdered them, murdered a family member, and something like that. When you have people sitting in prison on UMP charges, which is a paper crime, which is a 14-year felony, but we're going to allow people to have their sentence re-looked at after committing murders after 10 years, you know, we have to look at the whole system in general and not pick winners and losers on this. And I think the nonviolent and the elderly people that are in prison, the sick people and things like that are the ones that we need to be taking care of first, see how that goes, and then we can take a look at the more violent offenders.
Yeah, Rep. Mueller, I appreciate your concern. I guess the one thing I want to highlight there is that keeping in mind that these individuals have to go back to their same sentencing judge in the first place. So I think it goes back to what Rep. Ayash was saying, is that you're basically questioning our judge's discretion here, taking it case by case. This is not an automatic resentence. It's not any kind of automatic release. And so these are judges that are taking their own cases individually, case by case.
I'll just comment on your question around the 10 years. So nationally, you have about 17% of inmates that are serving 10-plus year sentences. In Michigan, it's about double that, almost at 17, at 30, over 30%. And then for those of them that must serve at least 10 years before they're even eligible for parole, we're looking at nearly half of the prison population. So as Representative Hope mentioned earlier, we're about 1,000 people understaffed. And if we're going to lean on a Department of Corrections that is supposed to my colleague's point, help people make right, then it's incumbent on us to look at situations where you have folks that have between 10 and 200-year sentences. So the question that we have to address as legislators is, where can we see the process built out? And I introduced a bill earlier this year to address our sentencing reforms by looking at establishing a commission to assess which crimes are worthy of longer sentences and which crimes are worthy of not. To your point, you talk about drug offenses. That is something that we clearly have seen a shift on as a society from the 1990s till 2024. So that's something that should be looked at. But broadly speaking, if we are going to say that we are the stewards of the public taxpayer money, then we have to look at how much is it costing us to keep people in prison, up to $70,000 a year. If you have someone is 70 years old and they have to serve the rest of their life out, and they're going to live another 15 years in that prison system, and there is demonstration of redemption, there's demonstration of those types of qualities that we want to see come out of the criminal justice system and come out of our correction system, then we're looking at spending $1 million to keep someone in prison to die in their late 80s, when if we have a process like this established, we allow them to petition to have the conversation with the judge that gave them that sentence and engaging the victims, like we have an example here today, to be able to say, can we see this as a point of redemption? Can we see this as a point of correction for that individual? And is there a public benefit to keeping them locked up, spending $70,000+ a year for an aging population? Or can we see a world where they can age gracefully after they have served and done their time in our prison system?
I would like our forgiveness to matter.
Okay, we have a question for bill sponsors.
Yes, real quick.
Representative Carter.
Thank you, Madam Chair. So I'm listening, and you said the sentencing judge, 10 years. Are there any provisions in there in case the judge is no longer on the bench? How do we address that? Because we have retirements, deaths.
Yeah, I'm glad you asked that. So it would go to the same jurisdiction, the succeeding judge or that jurisdiction. So someone can't just go and petition some other county because they heard that this judge is whatever. They have to actually go to that same jurisdiction.
Okay, that's reasonable. As someone who's worked in every court in Wayne County, I've seen judge turnover, or they move to circuit, to appeals, or somewhere. I just wanted to know if there was a mechanism. Thank you.
Thank you. Thank you, Ms. Bailey.
Thank you.
I'm going to call up now Jeff Morinoff and Ford School of Public Policy students. If you could please keep it succinct. I got to know your the policy briefing yesterday, and I know there's a lot to it, and a lot of people worked on it, but time is limited.
Okay. Thank you, Chair Hope and members of the committee. My name is Jeff Morinoff. I'm a professor of sociology and public policy at the University of Michigan, where I also serve as the Associate Dean for Research and Policy Engagement at the Gerald R. Ford School of Public Policy. I also teach courses in criminology and criminal justice policy, and have been recognized by Thomson Reuters on its list of highly cited researchers. I've conducted extensive research on sentencing, recidivism, and reintegration in Michigan, using data collected from numerous state agencies, including the Department of Corrections, the Michigan State Police, and the Michigan Unemployment Insurance Agency. In one of our studies, our team collected data on a cohort of over 11,000 people released from Michigan prisons onto parole in 2003, and used administrative records collected from these multiple state agencies to track their outcomes for almost 10 years, studying their recidivism, their employment outcomes, and other outcomes related to reintegration, such as their living arrangements, residential stability, and education. In another study, we examined the effects of incarceration on labor market outcomes and recidivism and violence in the community and health, based on data on over 140,000 individuals convicted of felonies between 2003 and 2006. And in our 2019 book, On the Outside, Prisoner Reentry and Reintegration, my colleagues and I conducted in-depth interviews with men and women before and after their release from prison, and followed these individuals for up to 5 years as they progressed through the reintegration process. Most relevant to today's proceedings, I supervise this team of 5 Masters of Public Policy students in my Strategic Public Policy Consulting course, as they worked on a project analyzing the potential cost savings that would be realized if second look legislation were implemented in Michigan. As one of the team members who's sitting next to me right now, Noah Attal, will explain, they collected demographic, legal, and criminal history data on every person currently serving time in Michigan prisons. They used this data, along with estimates of parole rates, recidivism, and the life expectancy of people currently serving time in Michigan prisons, to run a large-scale simulation model that reveals how many person years of imprisonment would be saved by the implementation of second look legislation. They also conducted an economic analysis to estimate the substantial cost savings from this reduction in prison time, using data on the marginal costs associated with incarcerating individuals in Michigan, including things like healthcare, food service, transportation, and facilities administration and maintenance. Finally, they estimated how even larger cost savings could be obtained by reducing the size of the prison population to an extent that some facilities could be closed, which would also help alleviate the problem that some prisons are currently understaffed because they cannot fill their number of allocated prison positions for corrections officers, as the chair has already referred to. And with that, I turn it over to Noah.
Thank you, Chair Hope, for the opportunity to address the Criminal Justice Committee today, and good morning to all committee members. My name is Noah Attal. I'm a Master's of Public Policy and Information Science student at the University of Michigan. I'm joined by my peers today, Julia Block, Allison Hanley, Maureen Hilton, and Kenan Kabani. Together with American Friends Service Committee, we have compiled the booklet, Second Look Legislation Policy Briefing, Modeling Cost Savings Under Second Look, that was provided to this committee. With my time today, I intend to firstly outline Michigan's sentencing problem, secondly, review statistics on MDOC's current incarcerated population, and lastly, address key takeaways from our analysis of cost savings of second look legislation. I'll be roughly following the figures in this booklet, and I'll mention page numbers for anyone who wants to follow along. Starting off with figure 1 on page 3, Michigan has a sentencing problem. 1/3 of Michigan's incarcerated population has already served at least 10 years. That's nearly 2 times the national average. Nowhere else in the country has a higher percentage of people serving long sentences. This presents distinct problems for Michigan and MDOC. Firstly, these long sentences have contributed to an aging population that has increased health and medical costs for MDOC and Michigan holistically. Secondly, there is robust research suggesting that individuals tend to age out of crime as they get older. Therefore, long-term incarceration may have diminishing returns to public safety, and many sentences hold people in facilities past the point they pose a risk to their community. Lastly, while Black people are disproportionately represented at every level of sentencing in Michigan, racial disparities in sentencing are most severe amongst those serving long sentences, like life imprisonment. Looking at figure 2 on page 4, we can see as of September 2023, there are over 32,000 people serving sentences in Michigan, 17,000 of which have minimum sentences of at least 10 years, and 4,400 are serving life sentences. This means that over half of Michigan's incarcerated population are serving long-term sentences, and 1/3 are serving extremely long sentences. Figure 4 on page 6 shows the racial and ethnic breakdown of the incarcerated population. While Black people in Michigan make up 14% of the population statewide, 1 in 2 individuals incarcerated in Michigan are Black. Looking at figure 5 on the same page, we can see the sentence distribution by race and ethnicity. We see that roughly 1 in 4 Black people incarcerated at MDOC are serving sentences of 20+ years, and 1 in 5 are serving life sentences. This disproportionate representation of Black people amongst those serving longest sentences in Michigan underscores that Michigan's sentencing problem is inherently an issue of racial justice. By creating avenues for sentence reevaluation, Michigan can take a step forward in addressing these inequities. Looking at figure 7 on page 7, we see the distribution of sentences by county of origin, and therefore the county that would handle the resentencing hearings. More than 1/3 of all life and very long sentences currently being served in Michigan were handed out by judges in Wayne County. Because Wayne County towers above every other county in Michigan for such sentences, and by such a large margin, it's hard to see the distribution in other counties. We've attached an appendix in this policy brief so you can see those numbers. This shows that while communities everywhere stand to gain something from Second Look, most counties will not be dealing with a high volume of applications. Figure 9 on page 9 shows the life sentences of all individuals in MDOC by the decade they were given. We see that many people were sentenced decades ago, and there are currently 22 people in MDOC who were sentenced in the 1960s. That means they're over 80 years old now. This highlights the impact of long sentences and how, despite changes in sentencing sentiments, we are still impacted by the decisions that were made decades ago. I'll now move from describing the MDOC population to talking about the model our team developed and its results. Our team developed a cost-saving models for Second Look legislation to estimate how much MDOC would save if Second Look was enacted. As part of our model, we web-scraped the offender tracking information system to get the most up-to-date data on Michigan's incarcerated population, and then we estimated how many years each individual could potentially save under Second Look. Figure 10 in page 10 outlines the assumptions that we made on how judges might implement Second Look. These assumptions are by no means a guide for judges. We understand that every single individual will be sentenced and reviewed separately in accordance with victims, family, prosecutors, and the judge. Figure 11 on page 11 shows some estimates from our model. We estimate that there are around 5,400 individuals who currently could benefit from Second Look according to our assumptions. Over the next 10 years, we expect that number to increase to 10,000 individuals. The significance of this number cannot be understated. If half the eligible individuals receive some sort of sentence reduction under Second Look, Michigan could see significant reductions in the proportion of its incarcerated population that's serving long-term sentences. Figure 13 on page 13 shows that Second Look could address some systemic issues in MDOC. MDOC struggles with severe staffing shortages. Approximately 1 in 5 correctional officer positions are vacant. I'll repeat, 1 in 5 positions are vacant in MDOC. If Second Look is implemented and 5,400 individuals receive some sort of reduction, MDOC would be able to close some of its facilities. The facilities listed in Figure 13 are those with the highest correctional officer vacancy rates. Closing these facilities would not only save $188 million annually, it would also almost completely eliminate MDOC's staffing shortage. That means $2 billion over the next 10 years. In summary, Second Look will impact incarcerated individuals with the oldest and longest sentences in Michigan, giving an avenue for resentencing for almost 10,000 people over the next 10 years. With 2 in 3 individuals serving life sentences identifying as Black, this legislation is likely to address racial disparities in Michigan's incarcerated population as well. We modeled significant savings for MDOC. With facility closures, we can see savings of $2 billion over the next 10 years. I yield the rest of my time, and thank you.
Thank you. Thank you, gentlemen. Thank you, students, for your research. We do have a couple of folks who have traveled here, and I want to make sure they get an opportunity to testify. Former State Representative Anthony Forlini, who now serves as Macomb County Clerk, please come up. Be brief if you can.
Good morning. Thank you, Chairwoman, for the opportunity to speak, and members here. Macomb County Clerk, what does it have to do with what we're talking about today? Absolutely nothing. But as a former legislator, I got involved with what we're talking about, trying to understand what was going on in our prison systems and understanding that there is a problem. And I'd like to address some of that today and kind of get into what I believe there might be some compromises in how we get there. First off, let me just say, I don't agree with those that might spew anti-police rhetoric, allows criminals to run the streets that happen in some states. I'm not soft on crime. I do believe, however, in quick, decisive, and firm corrective action. Corrective action that promotes positive results and future leaders in our communities, some of them you heard today. It does not necessarily mean jail time, but rather mentorships with our young, mentorships that will move them in the direction of hope. Now, I'm a Republican. There are plenty of red states that have successfully had political courage to take conservative moves to free taxpayers of the unnecessary burden of over-incarceration. Current law in Michigan is flawed. Legislation is required to fix some of these injustices and short-sightedness that exists today. Life without parole is where I believe we need to make the biggest change. It is silly to think that just because somebody is eligible for parole means that it is granted. Charles Manson's a great example. He's offered parole 11 times. Rightfully, he died in prison. We need to keep people that are a problem or a threat to society in prison. But there are lifers in the state prison system that are no longer a threat and have served their time. As a Michigan taxpayer, I do not want to pay for the room and board, health care, and security for those that are no longer a threat, just because we don't have the political courage to do something different. When I was in the legislature, I heard a story of a quadriplegic prisoner with no use of his arms or legs. He was a lifer. Should we fear him? Do we need to pay for this man's upkeep? Right now, there is no option to release a lifer that is no longer a threat to society. Behind me in the crowd, there are 2 siblings of a man that has served 33 years in our Michigan prisons. This man's name is Antonio Serralo. Antonio was a family man before he got messed up with painkillers and illegal drugs. Initially, it was to quiet his back pain as a result of years of cement work. But one fateful evening, he shot and killed 2 individuals. At that time, he was offered a plea deal of 10 years, but didn't take it. Keep in mind, he's been in there over 33 years. Now, before this event, Antonio had many friends, a big brother to his 6 siblings, a father to his daughter, and now grandfather of 3, the youngest of which was named after him after he was incarcerated. We have many letters from current and past politicians, the very people that were involved in Antonio's original conviction, and the current prosecutor in Macomb believe that he should now be allowed to be released. This is based on the mentorship and guidance he has given other young men that are incarcerated, as well as the respect he has given the warden and guards that watch over him. Antonio has a loving family, a family filled with successes, and that all of them are hoping that one day to bring him back into their homes. Antonio is also a citizen of Italy and probably long ago should have been sent back to his birth country. But under current laws, that couldn't happen. I have visited Antonio many times. He's an elderly man that helps those that are in wheelchairs, helps the young people. And I visited him. The first time I went, I was wondering if I was going to be looking into the face of a killer, because I wasn't going to support anything along those lines. But I saw a man that was remorseful and knew he had done wrong on that one fateful night. Today we have over 2,600 people over age 50 that are serving a life sentence. They have no hope of ever getting out, and many of them should not get out. But there are some like Antonio that have earned a second look. Now, let me just say that I think the current form of the bill has gone a bit too far. Suggesting that 10 years is enough to change someone is a mistake. And I think many people that I know believe the same thing. And having it such a short resentencing time, being that I'm the county clerk, I think it's going to add an overwhelming workload to the circuit court system and docket. So I worry about that. I asked the current bill sponsor, as well as the committee, to work across the aisle and come up with a common sense bipartisan bill that gets the job done of freeing Michigan taxpayers of unnecessary costs and yet protect us from the obvious threats. That being said, there was a time Antonio, as well as many, if not all lifers, deserved to be in prison. But there comes a time for those that are reformed and no longer a threat. And when they hit that tipping point where we're at that point where the taxpayer is really the one that's being suffered right now, paying a disproportionately high price tag for these people. I'll end it there. I do have some suggestions I'll leave with the chairperson and the clerk regarding some changes I believe we need to make to first degree murder, specifically that section.
Thank you for your testimony.
Question? Real quick.
Oh, Representative Carter has a question.
Thank you for your testimony. Thank you, Madam Clerk. You know, I'm looking at something that you said. You said that had he taken that plea, he would have gotten 10 years. So we know that 97% of court cases are pleas. I don't know if anybody in here knew that. And you don't have the ability to appeal. But what I've noticed, and what you're saying is, and it appears to me it's more of a statement, that we'll make an example of you if you don't take this plea. If it was good enough for 10 years, then 33 years later, there's an issue.
And I think at some point in time, I mean, they realize that they made the mistakes they made, and there's a little bit of pride probably up front that goes in with some of these things, and denial, and in this case, possibly even not clear thinking. And here he is today.
Thank you. Thank you, sir.
Thank you.
Next, we have Nazgul Gandush from the Sentencing Project. And if you don't mind, I'm going to call up Dr. Robert Kinshirf from Harvard as well at the same time, just for the sake of committee economy here. And I know it's difficult, but please try to keep your remarks brief.
Thank you so much, Chair Hope, and thank you to the committee for this opportunity. I'm Nazgul Gandush, Co-Director of Research at the Sentencing Project. It's my pleasure to appear before you today in support of this Second Look bill. I've been researching criminal legal issues for 14 years and have published in numerous articles and chapters in academic and professional journals and books. And in addition to the reports I've been publishing with the Sentencing Project, which is a research and advocacy organization founded in 1986. Second Look laws are endorsed by national legal experts, such as the American Bar Association, which recommends a second look for everybody, regardless of the offense, after 15 years of incarceration. in the model penal code. And they specify in the notes to that recommendation that several people recommended a different starting point, and actually that was often at a much earlier stage than 15 years. The American Bar Association also has endorsed second look laws, and they recommend that second look begin after 10 years, as this bill does. And law enforcement organizations like Fair and Just Prosecution also have endorsed second look reforms. So approximately a dozen states around the country have some kind of second look reform beyond what's already allowed for juvenile sentencing. And so I want to talk to you very briefly about some of the criminological research that supports these reforms. So criminologists have identified 4 main purposes of punishment of incarceration, and that's rehabilitation, incapacitation, deterrence, and retribution. And I want to just briefly talk about how criminologists have also demonstrated that lengthy and extreme prison terms do not achieve those goals. They exacerbate racial disparities, which you've heard a bit about earlier today, and they're in fact counterproductive to advancing public safety because they divert our limited resources away from more effective interventions to prevent crime from happening in the first place. I've elaborated on these points in my written testimony, but today I'm just going to share a brief overview. So first, incarceration is intended to promote public safety by rehabilitating people who pose a risk to our communities and by incapacitating them until they can safely return home. But lengthy sentences incarcerate people well past this point, producing diminishing returns on incarceration. Criminological research using a variety of methods, including looking at recidivism rates, looking at the duration of criminal careers, looking at the age crime curve, have all shown that people tend to engage in criminal activity in their late teens and early 20s, and then they move away from criminal offending. So, for example, research by the Bureau of Justice Statistics and the U.S. Sentencing Commission has found that after 6 to 10 years of incarceration, recidivism rates fall dramatically. And that's because many of these people have aged out of criminal activity. Studies of people released after decades of incarceration, and this could be a population that gets prioritized when implementing this bill, have shown that people who've served the lengthiest prison terms are the least likely to recidivate. And they're far less likely to recidivate than other people who are typically released from prison, meaning that we've held these people far beyond the point when they pose a reasonable public safety risk. So second, in addition to incapacitating people when they no longer pose a criminal threat, long sentences also fail to deter others from criminal activity. And so there's a lot of research that has established this, and I want to just explain the reasoning for it, why long sentences don't deter people from committing crime. That's because people don't expect to be caught, and in fact, that's not an unreasonable expectation when you look at our crime clearance rates, even for the most serious crimes. People also commit crimes under the influence of drugs or alcohol, having their judgment impaired, or in the heat of the moment. And so the more that we can invest in effective drug treatment, effective mental health care, we would help to prevent these offenses happening more effectively than if we invest in extreme sentences and lengthy sentences. And third, incarceration is designed to achieve the goal of retribution. But as policymakers, it's important for you to understand, as you've heard today, that victims and survivors are not monolithic. They have a variety of perspectives on what length of sentencing is appropriate. And as policymakers, you're also entrusted to uphold the societal value of not inflicting too much punishment. It's very meaningful to me to be speaking to you as state legislators in a state that has been a leader in abolishing capital punishment. And in the same way that the state became a leader on that front, I hope that you will take very seriously your responsibility now to reconsider extreme and lengthy sentences. Thank you.
Thank you. Dr. Kincher?
Good morning, Madam Chair. Thank you. It's a privilege to be here, and I will be, as my colleagues would call it, uncharacteristically succinct, but I'll try and achieve that goal today. I also want to thank the clerk for accepting our monograph that we have published summarizing the science on adolescent and young adult neurodevelopment and social development, because those are the peak years for criminal activity, although we have drawn a line at age 18 that actually does not have much of a real reflection of any known science. There's nothing magic about the age of 18. My name is Robert Kincherf. I have had the distinct privilege of seeing the arc of criminal involvement over the course of the lifespan. Began my career as a senior forensic psychologist in the Boston Juvenile Court, which also has jurisdiction over what we call child protection cases. You may call them dependency cases, but they're basically the child abuse and neglect, status offenders, delinquency, youthful offenders. I also had the privilege of serving in Massachusetts as the Assistant Commissioner for Forensic Mental Health, responsible for the training and deployment of forensic mental health professionals in both the adult and juvenile systems. I can't keep steady work. I've also been the forensic examiner for the Massachusetts Parole Board and have worked very specifically on both long-term cases, life cases, and also youthful offender kinds of cases, people who were sentenced at 17, 18, 19 into our system. All of that just to say that I think I've got a pretty good view, and I'm not an academic in the sense that I sit in a university and observe and read and write papers. My goal and the goal of the organization that I'm with, the Center for Law, Brain, and Behavior at Mass General Hospital of the Harvard Medical School, is to take research and apply it into practice in areas that involve law and policy. So what can the science tell us about the criminal justice system, and in particular this context, second look initiatives? So first of all, from normative adolescent neurobehavioral development, just what your standard issue teenager is all about. Their brains, as you all know, is now very much part of popular culture in the process of reconstruction. There are reasons, biological reasons, why they are more reckless, impulsive, have difficulty appraising risk, which they can usually do pretty well, but then applying it to their individual circumstances, and they're wretched at that, and they continue to be vulnerable to that kind of challenge to their decision-making as they grow up until they hit between the ages of about 19, 20, up to 23, where we've known since the 1920s there's this phenomenon known as the age crime curve, where even youth who were violent and chronic delinquents at 14, 15, 16, they essentially have this intersection of brain development and social maturation where most of them simply don't make the career choice to be a career criminal for the rest of their lives, and if given opportunities, will often self-desist without prosecution or incarceration. This risk-taking is seen not only in criminal misconduct, you see it in higher rates of substance misuse, higher rates of drowning. In car insurers, and parents can tell you, higher rates of accidents in cars, higher rates of unintended pregnancy, all of which skyrocket in mid to late adolescence and then drop off as they learn more about the world. So we know that there's this phenomenon. We seem to have drawn a line at 18 that assures that we're going to catch in the net some of the people who are simply going to stop behaving this way if we afford them meaningful opportunities as an alternative to criminal activity. We also know, and we've known for some decades now, that the risk of long-term sentences has no deterrent effect on youth. Partly it's because they don't believe they're going to get caught. Sometimes they think it's worth the chance in the heat of the moment, and sometimes they're impaired by drugs, alcohol, or negative peer influences. We've known since the Supreme Court acknowledged this in the Roper case in 2005, which constitutionally banned the execution of persons for crimes committed under the age of 18. We've known that the heinousness of a crime committed as a young person is not a reliable predictor of their ultimate capacities for change and rehabilitation as an adult. You can't look at the seriousness of a crime at 16, 17, 18, 19 and say this person's life is done. In fact, in the Roper case on the issue of execution, the Supreme Court specifically pointed out that it is extremely difficult. If they had been a little braver, they would have said the whole truth, which is it's impossible to look at somebody in mid-adolescence or early young adulthood and reliably predict how they're going to turn out. We simply don't know how to do it. And if we try, we mostly get it wrong because of the age crime curve. We're trying to predict into the face of it while the tide is going out. one little factoid on that, which I just find astonishing. After the Miller case, Pennsylvania had to release 271 juveniles who've been convicted and sentenced to life without possibility of parole on murder charges. 271 of them were released. The releases started in 2013, 2014. As of the last updated publication of the data, 3.5% of them had a new arrest. That's 6 out of 271. That's arrests, that's not convictions. There were 2 convictions. One was for contempt, which as near as I can figure out in Pennsylvania means disorderly conduct, and the other one was a lower level robbery. Now you would think that if these were the worst of the worst, the juvenile killers, you would have a higher criminal recidivism rate at all, much less coming back on serious crimes. It's astonishing it's only about 3%. But let me wrap up here. The current criminal justice system actually works inadvertently, to be sure, but effectively to actually increase recidivism rates among young people who come into contact with it, especially those between the ages of about 14 and 25 or 26. If a punitive response would work, you would expect the states that have the most punitive and aggressive criminal justice responses to youthful crime to have the lowest recidivism rates. In fact, they don't. They have the highest recidivism rates when you look at them collectively. So the second look approach maintains motivation for change by allowing somebody to continue to hope. I have seen people who have served most of their lives in prison. I met them when they were 14, 15, 16 because of changes in the law and because I'm an old geezer. I've now seen them again in their 40s and some of them in their early 50s. And the capacities for change are really quite remarkable. And almost all of them attributed the change to their hope that at some day they could demonstrate their redemption. Second look is about accountability, but it's about developmentally aligned accountability and helping people foster that change. The legislation does not assume a release. Release is only possible if it's demonstrated at 2 points, first to a judge and then to a parole board. And we also know that if you can eliminate unnecessary costs for unnecessary incarcerations, you can actually afford to fund the pre-vocational, vocational, and educational opportunities that we know are the best chances for success when people are ultimately released. So my plea to you is, from a public policy point of view, I think this makes perfect sense if you follow the science. If you just follow the science and say what actually works. Because lowering recidivism rates, lowering costs, that is not a red or a blue issue. That's a what is really working here issue. If we can agree that if we can lower the recidivism rates and we can prepare people to re-enter our communities, over time, what we will see is what some other states have seen, actually improves community safety over time rather than threatening it over time. So I urge you, follow the science. Ask the question of what will really work here for Michigan. Thank you.
Thank you. All right, we need to get Prosecutor Jeff Getting, representing the Prosecuting Attorneys Association of Michigan, and Dave Kirk, if you don't mind coming up together. Dave Kirk from the Michigan Association of Chiefs of Police. And if you could please be brief. Thank you. Go ahead and start whenever you're ready.
Do you want to go first? All right. Madam Chair, members of the committee, thank you for the opportunity to address you here this morning. My name is Jeff Getting. I am the Kalamazoo County Prosecuting Attorney. I am the current president of the Prosecuting Attorneys Association of Michigan and also the former legislative committee chair for that organization. I am testifying regarding House Bills 4556 through 4556 through 4560 in opposition to these bills, not only in my personal capacity, but also as a representative of the Prosecutors Association, whose legislative committee has voted unanimously in opposition to these bills, regardless of party, regardless of geography, regardless of any other characteristic. We are in unanimous opposition to these bills. I want to take a second to clear up what I think are a couple of misconceptions or misunderstandings about prosecutors and about our role in the system. Prosecutors do not love to lock people up. That is a last resort for prosecutors, for all prosecutors across the state of Michigan. And in fact, statistically, that is borne out by the Michigan Department of Corrections. Less than 1 in 5 persons convicted of a felony end up sentenced to prison for any length of time. Less than 1 in 5. We are not interested in mass incarceration or in continuing mass incarceration. With the support of prosecutors' offices across the state, the Michigan Department of Corrections population over the last decade has been reduced by 40%. We went from over 50,000 people in our prison system to approximately 32,000 over the last 10 years. And that has been with the support of the prosecutors in this state. We do not want to keep people in prison who are old, who are medically frail, which is why we in fact supported legislation that was adopted in this state approximately 5 years ago, allowing for the release of medically frail prisoners from the Michigan Department of Corrections who were serving lengthy sentences. That this legislation is being sold as a way to get medically frail prisoners out of our system is not accurate. We already do that. And in fact, you have pending before the House bills that will tweak the medically frail legislation that has already been passed. Lastly, in the state of Michigan, we do not lock up everybody for long periods of time. Over 75% of the persons who are serving time in Michigan's prison, any amount of time in Michigan's prison, are there for having committed violent offenses. There is no one serving 20 years in prison in the state of Michigan for having sold cannabis. That is not true. That is not who this legislation will release. Who this legislation will release is violent offenders, rapists, robbers, murderers. That is the only people in the state of Michigan, almost exclusively, that are sentenced to 10 years or more. It just doesn't happen, and this only applies to them, to those persons who are serving 10 years or more. These bills will make our state more dangerous. Exclusively, every prosecutor I know says their job is to make their community safer. This does the opposite. It will release almost exclusively violent offenders. Almost no one else, as I said, gets 10 years or more. And to use the idea of correctional staffing needs to be addressed by releasing violent offenders into our communities. Staffing levels do not get addressed by releasing violent offenders into our communities. Staffing levels get addressed by paying more, hiring more, making the job a better job, making the job a safer job, providing better circumstances for those persons that are incarcerated. That's how you address staffing levels. You don't address staffing levels by letting violent offenders out. This goes in front of the same judge. Well, maybe, but if somebody's been in prison for more than 10 years, it's just as likely or more likely that they'll go in front of a successor judge.
I'm very sorry to interrupt you, but we do have a hard stop at 10:30, and like to hear from the chief here.
All right, one more thing. This addresses mass shootings. You have defined a mass shooting as someone who has killed 3 or more persons in a single instance, the Ethan Crumbly exception. But if I place a bomb in a classroom and kill 10, I get released or looked at for release after 10 years. And if I have asthma, I am presumptively being released after 10 years. That's what this legislation says. If I kill 2 people on one end of campus and walk to the other
Sir.
side of a college
Sir.
campus and kill 2 more,
We'd like to hear from the chief now.
this legislation presumptively will
We have about 2 minutes before our committee concludes, and we need to hear from the chief.
Madam Chair, Committee, thank you for the opportunity to address you this morning. I represent the Michigan Association of Chiefs of Police as a chair of their legislative committee. We're here to oppose House Bills 4556 through 4560. Contemporary law enforcement pays attention to bias in all forms. A review of these bills, both macroscopically and microscopically, there's no doubt and no question that the priority is to the offender as opposed to the victim of the crime. The crimes that we're talking about are not petty crimes. They're not things easily dismissible. They're the type of crimes that are horrifying and terrifying to the victims that they were perpetrated on and their families, for those victims who did not survive, that were killed in the incident. We talk about victim consideration being absent in these bills. I continue to look for something that addresses the victims specifically. It does address the victims, and the opportunity they get is to be pulled back into court to face the people that they had to face once in the justice system, that they were promised if they followed that process, they would be taken care of. And you adhere to that justice system, yet we're going to pull these victims and their families back in to establish a factual basis. I would ask the committee, as these continue to be deliberated and discussed, that you do a role reversal, place yourself in the position of a victim of these crimes. In doing so, if you were the victim of this crime, would the cost of correctional officers be a consideration for you, or would the safety of you and your family be the consideration? There's no real need for hypotheticals. We've heard testimony, and the last time a lady testified to being stabbed while her boyfriend and brother were killed in an incident. That's the type of incidents that this allows. The reference, yes, ma'am.
I apologize. I have a member question up here.
Question for the prosecutor. Just wanted to ask if you were aware of the Kalamazoo County statistics on black youth being arrested and prosecuted within the county, and the rate at which black youth are arrested, prosecuted, and incarcerated in your county compared to all other populations?
I don't know exactly how to answer your question because I don't know how to define black youth and who you mean.
Oh, okay.
But I do know.
Maybe you could continue this conversation offline. We do have some procedural things we need to do before we conclude here.
I'd like Representative Andrews to define who he means by youth. Are we talking about under 17, over 17, under 25?
Representative Carter moves to excuse absent members. There being no objection, the motion prevails by unanimous consent, and there being no further business before the committee will stand adjourned.